Hello and welcome to this presentation on the Biden administration's June 2024 Proclamation and Interim Final Rule on Securing the Border. My name is Dina Sharouk, and I'm a Senior Legal Advisor to the American Bar Association's Commission on Immigration. After viewing this video, you will have a better understanding of what the latest asylum ban does, who it applies to, who is exempted, and how the policy is being challenged in court. Let's begin. On June 4, 2024, President Biden signed a proclamation suspending the entry of non-citizens at the southern border with very limited exceptions. These restrictions have already been implemented. That's because the policy is triggered when the number of individuals who cross the border without legal status exceeds the limits set by the administration. So until numbers decrease significantly, most non-citizens will not be allowed to enter the country at the southern border. This ban is even more extreme than the circumvention of lawful pathways restrictions that were imposed at the southern border in May 2023, because the most recent ban now applies to folks of all nationalities, including Mexican nationals. This rule also makes changes to some of the asylum process, including that individuals who enter the United States outside of a port of entry are ineligible for asylum unless they can show that exceptionally compelling circumstances exist. Now, when deciding whether an applicant should be screened for asylum, DHS officers will no longer ask non-citizens whether they fear return to their home country. Instead, they will provide general information about asylum and refer a non-citizen for screening only if the non-citizen affirmatively expresses their fear of return. This is often referred to as a shout test. Another change is that the screening process for whether an individual is permitted to apply for asylum, what we call the credible fear interview, will now have a higher standard of proof. While in the past, an asylum seeker needed to establish a significant possibility that they qualify for protection, asylum seekers will now have to show a reasonable probability that they qualify for protections. This is a new standard introduced in the proclamation. It remains unclear how high this standard is, but guidance indicates that it is higher than the previous significant possibility standard and probably lower than the standard for a reasonable fear interview, which is a reasonable possibility. So who is still allowed to enter the United States through the southern border? As we mentioned before, there are exceptions to the suspension of entry. Here's a list of groups who are still permitted to enter the United States through the southern border, even while the proclamation and rule are in effect. Lawful permanent residents of the United States. These are individuals who hold a green card. Non-citizen nationals of the United States. This is a relatively small group of people. For example, some folks from American Samoa or Swains Island may hold non-citizen national status. Individuals who use the CBP-1 mobile application and who are able to schedule an appointment at a port of entry. It is worth noting that while the CBP-1 app allows roughly 1,450 appointments a day, the demand for these appointments is so high that the average wait time for an appointment through the application is currently several months. Unaccompanied immigrant children. Victims of trafficking. Non-citizens with a valid visa or lawful permission to seek entry into the United States at a port of entry for an appointment. This includes members of the U.S. Armed Forces, U.S. government employees or contractors and their accompanying family members, non-citizens with a valid visa or who have the necessary documents required for admission at a port of entry, and individuals traveling on the Visa Waiver Program. CBP immigration officers have discretion to permit individuals outside of these groups to enter the United States after considering a totality of the circumstances, which includes consideration of public safety, humanitarian, and public health interests. These are individuals with exceptionally compelling circumstances, like a medical emergency. CBP officers can also exempt individuals based on operational constraints. For example, if the agency does not have enough detention space to hold an individual or family, or cannot quickly remove someone from the United States to their home country. What happens if a non-citizen is permitted to enter the United States? It is important to note that if a non-citizen is permitted to enter the United States, they will still have to apply for legal status if they don't have it. If they are permitted to enter without legal status, they will immediately be put in deportation proceedings called removal proceedings. Individuals who are barred from applying for asylum may still be eligible to apply for protections that offer fewer benefits than asylum. This includes withholding of removal due to persecution or protection under the Convention Against Torture. These are two forms of protection that allow an individual to live and work in the United States, but are not permanent and do not offer pathways to become a resident or eventually a citizen. They also don't allow the individual to apply for their family members to come to or remain in the United States with them. So how long will this proclamation last? In the case where any litigation challenging the proclamation is unsuccessful, this suspension is set to last up until the weekly average of daily encounters at the southern border drops to 1,500 or less. The proclamation could be later reinstated if the weekly average of daily encounters between ports of entry exceeds 2,500. Let's talk about the potential impact of this policy. On June 5, 2024, ABA President Mary Smith issued a statement in opposition to this policy. In her statement, she highlighted the ABA's concerns that the latest asylum ban jeopardizes the safety of thousands of vulnerable individuals and families on both sides of the border and diminishes America's long-standing role as a sanctuary for the oppressed. Other advocates have similarly raised concerns that this policy is effectively a partial ban on asylum claims. Many of the individuals who come to the U.S. southern border are asylum seekers, and now they have to independently and affirmatively express their fear of return to their home country if they want to be given even an opportunity to apply for asylum. Advocates are concerned that this policy denies many of those individuals their right to seek asylum. This could translate to many people with legitimate claims for asylum being deported to countries where they will face serious persecution. Let's discuss the recent litigation challenging this policy. On June 12, 2024, immigrant advocacy groups brought suit against the Department of Homeland Security challenging the policy. In the case Las Americas versus DHS, the plaintiffs mainly argue that the proclamation and rule violate the Immigration and Nationality Act and the Administrative Procedures Act. Specifically, the plaintiffs argue that all non-citizens physically present in the United States or at the border have a federal right to apply for asylum regardless of their status or manner of entry. They also argue that federal law sets the standard for asylum screening as a significant possibility of persecution. The plaintiffs are suing to invalidate and vacate the policy. As of the date of this video, the case remains pending. Thank you for watching this video. If you have any questions, reach out to us at the Commission on Immigration at imcenter@americanbar.org. Thank you and be well.